Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. You know, one of the areas that we've been going through some estate planning, a little checklist of things, fun questions and that, and we've talked to you about the basics, which we've covered many times on the show, but want to get into some of these more advanced strategies with you, which we did with the CRT as an example. And one of those, one area though that's a kind of, maybe seems like a small thing, but it's one of those that so often is overlooked, and having a plan in place for this is so important, and that is safety. If you have a safe deposit box, you know, if you have a safe deposit box, what happens when, you know, do you understand what happens when you pass as far as access to that? Or if you went through a period of incapacity, making sure that whoever your designated person looking after your finances, for instance, is able to access that if it's needed. And another part of that safe deposit box is inventory. You know, do you have an inventory of it where in with your estate planning documents so they know the need to get in it maybe ahead of time? So Russ, you've probably run into this, and I think maybe even recently, I know I have, where not knowing what's in the box, do I really need to get in it? Can I, you know, and is it going to be subject to probate? Is there any way around that? How do we access that box?
That's a big problem that we've been running into recently, because it seems like the banks have different rules depending on each bank. Some banks, when you pass away, if you have someone that's considered a designated representative, maybe a trustee of a trust, if you have a revocable trust, you might be able to convince them that the trustee would be there to get access to the box. But a lot of other banks are saying, no, whatever's in the safe deposit box is a probate asset. And so you can't get into it unless you file a will and have an executor appointed in order to basically formally get into the box. Mm-hmm. And a lot of times we find the clients lose the keys too. We've had a number of cases where the executor in this situation had to get the box drilled only to find out that there was costume jewelry in it. So, you know, those are the situations. Whenever we're talking with clients about safe deposit boxes, we always say, make sure that your power of attorney specifically states the attorney in fact can get in the safe deposit box. And over time, if you have valuables in a safe deposit box that you want to eventually go down to your kids, why not give it to them now? Why wait until you pass away? And maybe do away with the box, because it's been a problem for us in the long run. Never put your originals in there, if like will, power attorney for healthcare, revocable trust. We usually suggest that you put those in a fireproof safe at your house and make sure, or in our situation, we offer that as a free charge to our, or no charge to our clients, of keeping them in our law firm vault.
So there's a way, and that's an excellent point as well, Russ. This is the time, you know, before something happens, that you want to take care of these things. So one, check with the bank. Would they allow you to put the the safe deposit box in your trust? You know, would they allow it to change the titling on it so that your successor trustee would be able to access it? As Russ said, a lot of banks are, you know, tough with that and may not allow that. The fact, and they take a position that may be counter to what your wishes are. This is the time to find that out. So if we need to make adjustments, as Russ said, maybe a fireproof safe at home, maybe other ways to deal with those valuables in there. So these are some of the little things that can be gotchas and cause some real headaches, though, at the worst of times. All right, we've covered some of the basics, a little bit of advance. Now I want to get into the Secure Act, because this is an area, this new legislation, that is changing potentially how your estate planning is going to need to be done. And the reason for that is what we call the 10-year rule. Okay, so that 10-year rule that's part of the Secure Act, what it says is that when your beneficiaries, when you pass and your beneficiaries are going to inherit your IRAs, okay, retirement accounts are the same, by the way, 401k, 403b, TSP, your thrift savings plan for federal employees and military out there, yep, same thing there. So this is going to force, instead of being able to stretch out distributions from that account over your beneficiaries' lifetimes, which was the old rule, now they have to take that money out within 10 years. Now that rule creates all kinds of potential issues when it comes to, one, it accelerates the payout of that IRA, so you got some tax issues to deal with. Two, when it comes to your estate planning in particular, if you've got a distribution that you want to go out to your beneficiaries, let's say, through trust, you want to be, and it's protected in the trust, of course, by having the IRA as, the trust as the IRA's beneficiary. But that money, as it's going out, now instead of being able to stretch out over their lifetime, 20, 30 years or more, we're talking about 10 years. That they've got to cash that out within 10 years. The tax implications could be severe. And again, if you wanted them to get less than, say, 10% a year, okay, and you wanted to control that, how are you going to go about doing it? So, Russ, this is one of the areas that was not a problem that now has become a problem.
It's become a big problem in a lot of estate planning, where the retirement account is the larger asset in the estate. We're still having to go in a kind of wait and see approach. So when we prepare our documents, we try to build in as much flexibility relative to those plans as possible. So for instance, if you have a married couple, husband and wife, I think the go-to is still everything to the spouse outright. You don't run into that 10-year rule. In fact, you still have the rollover. The spouse can receive the IRA asset and roll it over into a new IRA in the spouse's name and continue to handle it as if it were the spouse's IRA from the very beginning. But once you get down to the next level, when you're passing those assets to your children, there are all sorts of rules that come into play. One of them, and the main one, is the fact that they have to take it out over 10 years. Now, most of our estate planning that's done for clients that have wealth is in focusing on asset protection for the kids. We want to create trust for the kids, make the kids the trustees so they can control the assets, but we don't want the kids' third-party creditors to get at those inherited assets, such as spouses or ex-spouses, third-party claims, government claims. So what do we do with the retirement account? Well, if we're forced to take it out, have the child take it out over 10 years and they get it, well, then over 10 years, they're going to own that retirement account outright, so that will not be protected. So we're having to sort of change our focus with respect to the trust the children are receiving with their inheritance, make the trust the beneficiary of the IRA, but then set it up so that we can either we have to take the funds out over 10 years still, but have the option of either leaving it in the trust for the child or having the trustee pay the assets out to the child, depending on the income tax situation and the asset protection issues that come into play. And that's for the most of our clients that have adult children.
So you're finding a way basically to accommodate the RMDs, but not necessarily fully distributing those RMDs to the beneficiaries.
Yes, allowing them to stay in the trust.
And the trade-off being the tax implication,
Yes.
right? Because the trust then is going to have to pay the tax on that RMD?
Yes, and the trust pays the tax at compressed rates. In other words, for an individual, you may not hit the highest rate of tax until you're, I don't know, $300,000-400,000 in income. With a trust, you hit the highest rate of income tax at roughly $12,000. So chances are, if the trust is holding on to the distribution, they're paying the tax on it at the highest rate that you would under the law.
And is there a way, Russ, where you can just, say that you've got the distribution, that other ways to use the money to where it can still be taxed to the individual and yet remain in the trust?
Yeah,
is there any way to do that?
Yeah,
as a non-qualified, in other words, it comes out of the IRA piece, is there a way to pass the tax through to the beneficiaries while still retaining that money in a non-qualified account within the trust?
Well, unless the child is considered the grantor of the trust, which is very hard to do in these situations when you're trying to do asset protection, the trust is probably going to end up being subject to the income tax and the funds coming in. Now, there is a strategy that we can use that can allow for us to stretch out that payout regardless of the application of the Secure Act to that IRA account, and that is us revisiting that issue of the charitable remainder trust. So if, let's say, for example, instead of setting up the trust for a child to receive the IRA as a typical health and support trust, you set up the trust as a charitable remainder trust. In that scenario, the trust takes the funds from the IRA, pays no income tax on it. So you're converting what would have been an income tax asset to the child to a non-income tax asset to the trust. And then the trust pays the funds that they've received over time, over the child's life expectancy, basically, to the child, based on whatever formula you feel is necessary. And then at the end of the period, whatever's left goes to charity. So that is a way of stretching it out by using a charitable remainder trust.
That's an excellent way to go about it. And then depending again on everybody's the individual situation that you're dealing with, and this is one that's coming after the fact. So if you or that you can set up to specifically benefit non-spousal beneficiaries. Now, in that scenario, they're going to get that income. That's going to be taxable to them. But now it's just the amount that they're receiving that's taxable. Are they still going to get some benefit from the CRT as far as helping offset some of that taxable income?
Yeah, because the amounts they receive from the CRT, assuming that there's enough there for distribution on a yearly basis plus whatever additional amounts are necessary to pay the tax. Again, these are calculations that we can get into when we sit down with each client. It depends on ages of kids and things like that. But again, it's a way of benefiting from this. I mean, this strategy is one of the few where you may or may not have a charitable inclination, but if you really do want to stretch it out over a child's life, and it pays out more if the children are younger, then this is kind of a go-to. And again, you know, having the assets at the death of the child go to a charity is not a terrible situation.
Right. Well, and you can do it over. We'll talk. We're going to take a break. When we come back, maybe talk a little bit about how many beneficiaries can be receiving funds from that CRT, and thereby how long those payouts might be able to be stretched out as well. So, but first a break. Join us here. We'll be right back on the Retirement Report.